awareness to the grassroots level and disseminate various aspects and various important things, especially on the traditional knowledge system. We sometimes hear things like that this product, which we are using for generations or thousands of years, have been patented by USA, like neem products have been patented and all these things. So we have to aware our masses about this intellectual property right. And since we are in the higher education system, we are writing things, writing theses, writing research papers, doing scientific works and filing patents. So at that level, also we need to be aware of this aspect and the intellectual property right. And I will, in brief, introduce Dr. Neetu Pade, who is presently working as assistant professor in Department of Physics in GDC Talwari, Chamoli. She has done PhD in time-resolved fluorescence spectroscopy and has published a number of research papers in international journals of repute. She is associated with TIFAC, and she has also worked as patent drafter scientist in law firm RNA Technology and IP Attorney, Gurgaon. And she has drafted more than 100 patent applications for reputed institutions like National Innovation Foundation, IIT, TIFAC, and many more. She has participated in various national and international conferences and symposia. She has received Young Scientist Award in 2013 by UCOST, and her area of interest are time-resolved fluorescence spectroscopy, fluorescence-based sensors, photophysics and photochemistry of probes in homogeneous and heterogeneous environment, development of organic, inorganic, hybrid luminescent solar concentrators sensitized by nanoparticles. We share these interests together, and we have done our thesis work during the same period. So besides this, she is an ambassador of TIFAC and NEPAM, and she is working for promotion and support in the field of IPR. I thank you, Dr. Neetu, for all her support for this webinar and our further programs. So, and I also thank our principal who took time from a very tight schedule today, and other faculty participants who were very busy in college from early morning today till 6 o'clock, that they have all joined here. And I now hand over to Dr. Neetu. Thank you, Neetu. You can go ahead.
Thank you so much, sir, for your nice introduction. And I'm very thankful to this college who has given me this opportunity to share my views on the IPR. So, before starting the session, I would like to tell what is the intellectual property. So I think all of you have a basic knowledge of IPR, but still I want to tell you that the what is IPR and why it's needed to us. Intellectual property means the property represented by the product or a process emanating from the creativity of the human minds, human intellect, and creative ideas. Like it is an intangible property. Like if we have Am I audible?
Participants, please mute yourself. All the participants except speaker can mute. Or ma'am, you can, Archana ma'am, you can mute other participants, please. Mute the
Okay. Hello. So then, intellectual property is the property created by the human minds. So like it can be an invention, original design, trademark, geographical indications, copyright, and the recently added the semiconductor.
Ma'am, please unmute yourself.
Okay. Hello, am I audible? Hello.
Yes, ma'am.
Yes, so we can see in this picture, if we have a Apple laptop, there can be more than one IPs are there. Like LED display showing the patent because it involving the technology, and the body of the laptop is a design and Apple sign on this. Like it is a trademark. A user manual is a copyright under the copyright, and the layout of IC inside this like a motherboard or something. It's a layout design of IC. So in a one product there can be more than one IPs. Like it's a property which is created by brain, and through labor and resources we generate a property for like other properties. So why we need it? Actually it's protect our intellect. We can say that it's protect our intellects and exclude the other to using the same which was created by us, and utilizing we can use it to commercializing and earn from this. Okay, now the today's topic is the significance of IPR in the higher education, why we need it. Actually this is like a universities, higher educational institutions are the major contributor of innovation and research. So awareness of IPR, already awareness of IPR is well stabilized in the R&D sectors. R&D sector as S&T science and technology organization. But now more emphasis is given to the higher education or academic sector, because in a higher education system we are aware of it, but we don't create a or commercialize it to earn it. So government of India is generally giving the emphasis on this. So Indian education system is often further we can say that Indian education system is often criticized for not getting recognized in the world ranking. The major difference between the recognitions and the quality is the India does not give much importance or emphasis to innovation and research. So the government recognized this issue, and the National IPR Policy 2016. In 16, they drafted a IPR policy. This policy make a shift in the approach and attitude of the Indian government, and the primary focus of this policy is to promote the innovation and creativity among higher institution, because higher institution is a major source of research and innovations. That's why it's very important to us. Further, all we are know the NAC accreditation is very important for our colleges and higher institutions. So NAC is awarding up to a 24 points in an institution which set up an innovations ecosystem or a IP cell, and facilities for identifying and promoting the IPR facilities. So it's very important in the higher education system to getting a marks in the NAC accreditations. So like utilizations of this, we can utilize it for our own use, or by licensing or assigning. How we can earn from this IP? Further, we can utilize it for own use. Secondly, we can licensing with the other. We can give the franchisees, and like merchandise, we can also merchandise it. So we can earn from these IPRs. Otherwise, it is important for a common person or a businessman. For a common person can use it in academics. It's a pride for a common person if he has a IP. Like a businessman can be earn and invest on these IP and generate a brand value for it, and also commercialize through the IPR. Like, so in this slide, we have shown that why the IPR is significant or important in a higher education as well as in a common life. Now I will take one by one the different types of IPR. First, I will tell about what is patent. So patent is an exclusive right given to a person, uh, uh, granted by a government to a person to stop other from making, using, exercising, importing, or vending of our intellects. And patent is granted for an innovation or limited for a period. Generally, the patent is granted for 20 years. In the exchange of disclosing it in a patent specifications, I will tell more about what is a patent specification later. So the exchange for the disclosing it in a patent specification such that anyone having the average skill in the art can reproduce the inventions. It's a right to exclude other from using your inventions. So like in a patent, we involve generally 3 steps. It should be innovative, and it use a technological aspects, and third one is it should be industrialized. So if we generate a product or a process through our intellects, it's known as a patent. Right to exclude, actually it's a right to exclude other from using your inventions. Owner has qualified right to use the inventions. Like there are some example of patents. I have given this. In 1956, George Alfred D.
Actually,
Penny.
only first slide is visible. Or is it only visible to me, or
It's not
the
visible to others, sir?
only first slide is visible. You are
The second one?
presenting only the first is showing. It is only first showing here in the screen.
Okay, wait a minute, sir. Now it's visible?
Just a minute. Now the second one is there.
Sometimes in a full screen mode, it shows the issue.
So again, we have shifted to first one. This is the second one. Yeah, second
Now?
one is, yeah, second one is there.
Okay. So sir, मैं तो काफी आगे बढ़ चुकी थी. Okay, it's okay.
हाँ, इसको स्क्रीन उसमें डाल देते हैं, प्रेजेंटेशन मोड में डाल दो.
Actually, sir, it was not showing with the full screen mode.
अच्छा, no problem.
That's why I'm sharing this screen.
Taking one by one.
Okay. Okay, now it's visible to all.
Yes. Now it's fine.
Okay, okay, sir. So the intellectual. So I repeat it again, or it's okay to all of you?
Okay, you can. We are seeing it.
Okay, okay. Like I have shown this picture to show the how a single product can have a different IPs. Like in this pictures, if I have a this Apple laptop, LED screen is a patent. Like a body of the laptop is design. Apple sign shows the trademark, and user manual is a copyright, and layout of IC is the SICL design. Semiconductor integrated circuit layout design. Yes, sir. Yes. Hello. If you have any query, please you can ask. Hello.
Ma'am, can you go to washroom?
If anybody has a query, he can post it in the chat box. You post in the chat box. You go ahead.
Okay, sir. So intellectual property is the intellectual property is a property generated by the brain. Through resources and labor, we can generate a property. Like after that, I tell you the significance of the IPR in the higher educations. So I don't think so I need to discuss it again. The utilization and commercializations can, or we can earn money through these IPR through its own use, through the licensing and franchises and merchandise it. After that, I told you about the patents. What is patent and patent? And I was in that slide actually, famous inventor and inventions. So in this slide, I was showing the in 1856, George Alfred D. Penning, a civil engineer of Calcutta, petitions that the government of India for granting exclusive privilege for this invention. Actually, earlier to this, India don't have any patent act or any rights to give a rights to give. We can say that we don't have any Indian government don't have any policies to give a privilege the person who is inventing any instrument, process, or something. So in an 1856, the George Alfred D. Penning asked for its exclusive privilege for his invention, an efficient pankha pulling machine. This is shown in this figure. And further other invention like phonograph, telephone, aeroplane, rabies vaccine, all these are granted patent in a different areas. Like some other famous Indian inventions in that era is also shown in this, like nanocars, hepatitis vaccine. These are the example of patents. Further is just a other example of patents. Patents includes the technology generally. If somebody wants to file a patent, what should he do? So if you want to file a patent application in India, what to do? And what form should I fill, and how much is the fee? So I will tell you one by one. To filing a patent, we need generally 5 forms: Form 1, Form 2, Form 3, Form 5, and Form 18. So Form 1 is a detail of just applications of the applicant. Fee need to be paid for this to fill this form. For the Form 2nd is generally the specifications, detail of inventions, and particularly drawing or brief discussion, like we write a paper. It is just like the written in a Form 2. So it does not need any fee payment. Up to the page 30 and 10 claims are free. And the Form 3, whenever we filing the first time, we need to file the Form 3, the detail of foreign filing or similar invention, fee not required. While the Form 5, declaration as an inventorship, it's mean who invented this patent. Like we have to give the inventorship is a different than the assignee of the patent, who everybody can file the patent, who gives the right to that. Like in an industry, the person who has a right to like अगर हम कहें कि कॉलेज है, कॉलेज इज कॉलेज एक पेटेंट अपने नाम पे फाइल कर सकता है, बट वो उसका इन्वेंटर हो ये जरूरी नहीं है. तो इन द Form 5 वी हैव टू डिक्लेयर द इन्वेंटरशिप, who is the actual inventor of this patent. Hello, am I audible? Hello.
Yes.
Yes,
Yes.
ma'am. Yes.
Oh,
Yes, ma'am.
okay.
Yes, ma'am.
Okay. After this, we need to fill the Form 18, which is the request for examinations. It is within the 48 hour. We can file the Form 18 within the periods of 48 months from the earliest priority dates. Like priority date is a very important in filing a patent. Means when we are disclosing our invention, is it gives the priority date. After the priority date, we can file the a request for examination within the 48 months filing date. If it is not filed, the applicant deemed to be withdrawn. If we not file the Form 18, is very important to file the examinations. Actually, it's request for the examination. If we don't file this Form 18, so our application can be withdrawn. For filing the Form 1, we need to pay some fee which is equal to like a educational institute or a individual person can file this form with the rupees 1600, while for the if the institution or a company is filing, it need to be file a 8000 rupees. And form second, I told you that it does not need to fee extra up to the page 30 and up to the claim 10. But if you are filing claim more than 10, you need to pay for this. For a per claiming, we need to pay some money. Form 13 we don't need to pay any fee. For form 5 we also not need to pay any money. But form 18 is required 4000 rupees for the individual person, and 20,000 for the other than natural. Natural, it means the not an individual. If the company is filing, so it need to be pay 20,000 rupees. So for filing a patent, we require only 5,600 rupees. Or and other than the natural person, it means not an individual person, is company filing with his name is required 28,000. If you have any query up to this, you can ask me. Now, what is the filing procedure? We can file the patent application in a two-way. First is online mode and an offline mode. So for online mode, we can file through IP India online GOV through. We can file the patent. It requires a digital signature of class 2nd and 3rd. It's very important to online payment. To digital signature, we need digital signature. And for the comprehensive e-filing portal, it is like this. We can go through the IP India and online filing. The main page is shown like this. So you can generate your login ID or something. Up
Excuse
next,
me,
yes.
Dr. Neetu, can you explain the form number 3, details of foreign filing of similar invention? What should be should we look for filling the form 3? Can you explain?
Detail of foreign filing for similar invention. Actually, the person actually patent is not a territorial. Actually, it's a territorial right. It is not valid. Like if you want to file a patent in other country, if you have invented suppose you have invented a product and you want a right in all countries, so we have to file in each country. Like you have to file in India, you have to file in America, you have to file in UK. In all process, you have to file the applications. So detail of the foreign filing, form 3rd is a detail of the foreign filing. If the somebody from the USA wants to file the patent application in India, so we need to file the form 3.
Okay, thank you.
Okay, welcome. Next is a comprehensive e-filing portal. E-filing process. Now I am in the expedited examination. Expedited examinations means if we want to expedite the examination process, it means want a fast examination process. So who can do the expedited examinations? The startup, the person who is doing his startup, and a small entity. The application is a female, is also have a benefit to expedited examinations. And department of the government and the other government establishment, like a government college, we can also file the applications for expedited examination or a request for expedited examination. India is a ISA, IPEA in a PCT. If you want to file the application in the PCT means if you want to file an application in a different conditions, so you have to file a PCT applications. So we can also request for the expedited examinations. The agreement between the Indian Patent Office and the Foreign Patent Office.
भैया मेरी बात सुनिए, तेल में बनता नहीं है भरत का सब्जी नहीं।
Now what is the patent application processing? So in this diagram I have shown what is the how we can file the patent applications in a it's a hello.
Participants, please mute yourself so that speaker can speak without hindrance.
Hello.
You
Now
please
the
go
patent
ahead.
applications can be done through a three ways, like a PCT, convention, and ordinary. Ordinary generally is used for to file the patent in an Indian Patent Office. So first we will file a provisional specifications. Provisional specification, like if you invented a you are in the initial state of your technology, so you can file a provisional specification. After the 12th month, you can file a complete specifications. Complete specification and publish under section 11A after the expiry of 18 months. It means to after complete specification, the Indian Patent Office publish this patent in within a 18 expiry of 18 months. After the 18 month, it publish in a patent IP Indian website. So and it's start the if somebody has an issue, they can raise the issue on this after publishing this. But if there is no issue, the examination of application by the examiner done by this, which generate the first examination report. The first examination report, in the first examination report, the applicant need to submit its submit its response within the 6 months, and it can be extended to 3 months by submitting submitting form 4. It means within the 6 months you have to submit your response, and it can be extended by filling a form 4. And the examination of amendment by the examiners and patent design report put to the controller of the patent design issue. If he is satisfied with your first examinations, response of your first examinations, if satisfied, it can grant or a dispose your dispose, it can grant your patent. If it is not satisfied, it can generate second examination report or a subsequent examinations report. Further, if he's not satisfied, he if it is not satisfied, he also generate a hearing, or after if it's here after this hearing, he can grant or reject your patent. While in the another process, if you want to file a international patent applications, there are two ways. You can go through the PCT way or a convention way. In a PCT way, it's required 31 months from the date of the earliest priority dates. You can file your patent in the other country within the 31 months. While in the convention, you need to file the application in a 12 month. You can submit your complete specifications and immediately publish it, already publish or not before 18 months. So after that, you can the same process is applicable as in the ordinary patent applications process. Yes, any question? Next is screening and classifications. I should remove this slide because I don't think so it's very important. In the examination process, there are two ways. It's a formal examination and technical examination. Formal examination is just an you are there is a provision of like there are some in the Patent Act, there is some in a section 2 there are some invention which are not patentable. So the examiner can raise the issue in the formal examination process. So it is inventive, it is innovative or not. It's give some objection on this, the formal examinations. While if we check it is innovative or not, or it using a technical aspects is shown in the technical examinations. Then if he has ratio, he generate a first examinations report, and it is a first examination report is the gist of objections are communicated to the applicant. For the examination on reply, examination on reply of the applicant is check reply, re-examined, remove the objection which met the requirement, communicate and pending objection to the applicant. If the examiner is not satisfied, controller of the examiner is not satisfied with it, create a hearing, and in a hearing, technical discussion on pending objections between the applicant and the hearing officer. Hearing officer, you can be you are patent agent, or itself you can be your hearing officer. The if it is satisfied with the hearing, is grant, or if it's satisfied with your hearing, he grant a patent. If it is not satisfied, he can refuse your granting patent. So there is a basic timeline. The provisional applications to complete its specification, you can file a complete you have to file this complete specification within the 12 months, and request for examinations within the 48 month, and reply to first examination report within the 6 month. Form 3 need to file within the 6 month. Form 5 within the 1 month. You can also withdraw your application in between them, but you can only withdraw your application within the 15 month. After this, your fees will not refunded. If you withdraw your application within the 15 months, the patent office give you a fees back, and you can submit your hearing response within the 15 days. If somebody has an issue with your patent, he can oppose your patent by filing a pre-grant opposition. And if he has issue with your patent, after granting the patent, he can also file a post-grant opposition within the 1 year. So it's all about your patent. Next, next IPR is your design. So most of the people say the design patent, but design is not a patent. Design is a registered. So design is generally Design Act come into the existence in 2000, and its rule book is published in 2001. And recently there are some amendment in the design rule, which is published in 2021. So, but first we have to understand what is the design. Design means the feature of shape, configurations, pattern, ornament, or composition of line or color applied to any article. I will tell you the definitions of article in the next slide, whether it is a 2-dimensional or a 3-dimensional, or in the both form, by any industrial process or a mean. Whether it can be design can be done through the manual, mechanical, chemical, or with the combination of both. So the term of design is given for the 10 year. It is extendable to the 15 year after completing the 10 year by filing a form. So in a first slide, I have shown that the design is applied to an article. So what is the mean of article? By the laws, the article means any article of manufacturer or any substance, artificial or partially artificial and partially natural, and include any part of the articles capable of being made and sold separately. Something which is can sold separately, like there is a design of car. I will show the some example of design, like this is the mask. There is some patterns of colors, like a sofa is a design. This watch is a design, like this bicycle is also a design. So there can be a different design. Now in a first slide, I have shown that apply to any article, whether 2 or a 3-dimensional, or it a set of article can also be included in that. What's the mean of set of articles? Set of article means a number of article of the same journal character or ordinary sold together. So these are the set of articles. It is also design registers. So design of the set of the article. There are some example of the design of the set of article. So how we can file the design applications? There are the two ways, like online process and offline processes. So the electronic processing module, like mainly we can do a physical filing or a online. So physical filing, there are 4 IPO offices, like IPO office Delhi, IPO office Mumbai. It's a IP means intellectual property office Chennai, intellectual property office Kolkata. So for physical filing, we have to make a demand draft in the favor of controller of journal of design payable at the Kolkata. So Kolkata handle all the design applications. So requirement to file an ordinary applications, what we need to do. So application fees, 1,000 rupees for individual, small entity and startups, but it is 4,000 for the others. So what we need to file the application form number 1, which required a applicant full name, nationality, address, class number, priority date, if any, or prior registration date. Priority date, it means the first where we are disclosing our design. So signature and date, 2 sets of representation and illustration, various view of the article. Like if you are creating a design for your box, yeah, or something new, like a mask patterns. So you have to give the illustrative view of this article. The power of attorney, if required, you have to file a form 21. If you don't need to a power of attorney, you don't need to file a form 21. Assignment of the document, if any. If you have any such documents for the assignment, it means some other is the proprietor of your IP, then you have to give the assignment document also. Form 14, if applicable, is a small entity and startups. This form is only for the small entity of a startup, because government give a reduction in the fee for the small entity and startups. Next is some example specimen of the representation of the sheet. This type of sheet you have to give the patent office. If the patent office is satisfied, it generate a certificate like this, and it publish this design in the in its patent office journal. It's like this. So you can check if somebody write our design is registered or not. You can also check this design, or you can check in a patent office journal by the design number. It is provided in this with the different classes. Next IP is a trademark. So the concept of trademark, trademark is what is a trademark? Actually, it's a word, name, symbol, device, or combinations thereof. It means it can be a symbol or a word can also come together, or a name or a symbol come together. So trademark is a combinations of word, name, symbol, device, which is identify and distinguish the source of the goods and the services for one traders from the others. Why it is important for any businessman or to commercialize our product? It's provide an exclusive monopoly over the class of goods or services, allow a business entity to build public goodwill and the brand reputations, identify the source origin and the good or the services, assure the customer about the quality of the good and services. Like there are some trademark are given. I'm sure you can know all of these trademark. Like trademark can be including a service mark, trade names like Adidas. You can say it's a name. Adidas is a trade name. Collective marks, certifications of marks like BIS and is the certification mark, or hallmark hai. These are the certification marks. Tagline and a slogan. You can say that just like a Dil Mage More is a tagline or a slogan for Pepsi. So it's also a trademark. Shape, different type of shape is also like a Coca-Cola bottle. Its shape is trademark. Its shape is totally different than the other bottle, so it's also a trademark. Sound mark, like if we on our computer, it's come a window, Microsoft window, it's open, so it's give a different sound. So this is also a trademark. So trademark can be of a different types. Like if the trademark, when you are applying for the trademark which is not registered, you can write TM in your brand. While if it is registered, you can write R in your product. So TM and R is, TM is written when it is under the process or a application is pending or unregistered. While if you have a trademark for your product, then there you can write R for this product. Next come under next IP is a how to protect your trademark. Trademark registration is optional. However, the registration has a certain advantages. If some brand value is already is there, so you don't need to the mark your registrations. Some has some, but however, the registration has some certain advantages. Like what advantages are there? We will see this. Registration available at the national, regional, or international level. Identify registered for 10 years. Can be further renewed after 10 years. For the it can renewed after 10 years. In case of non-use, non-renewable, or non-policing, trademark rights are lost. The existing trademark register is governed by the Trademark Act 1999 and the Trademark Rules 2013, which is revised in 2017. So it's all about your trademark. Now the next come copyrights, which is very important for the educational institution because they generate a research articles, papers, books. So it's very important to know about the copyrights. So what is copyrights? Copyrights cannot protect an idea, it's protect the originality, fixations, creativity, criteria to work to be copyrighted. So what are the subject matter of the copyrights? Any literacy work, we can get at copyrights. For artistic work, like if somebody paint its painting or click a pictures, so or come under the artistic work. Dramatic work, musical work, sound recording work, and cinematographic films. We get trademark for all these. So who are the authors of the work? Who will get the trademark? Like a literacy or dramatic work, author will get the author is the owner of the copyrights. If somebody writes its book, so author is the owner of the copyrights. For the musical work, music composer is the owner of the copyrights. For artistic work, other than a photograph, some like a painting artist, for like a painting, the artist is a owner of the copyrights. Photograph, the person who is taking the photograph. And cinematographic or a film recording, a producer is a owner of the copyrights. Literacy, dramatic, music, or artistic work, which is a computer generated, the person who caused the work to be created. Like if computer generate any, like it's a very questionable that if AI is generating the literacy, dramatic, or a musical or an artistic work, who is the owner of the copyrighted? So it was a long-lasting questions, but in a recent order, the government has given the right to the person who caused the work to be created. like who has caused the work to be created is given to the right for the copyright. So now, there are the right for the author of the copyright work. There are two types of right for the copyrights: economic right and the moral right. Economic right, like if you write a book, you can transfer your you can generate your economic through giving giving your concern for using your work by royalty. The money or the royalty depending on the proposed uses of the work. You can get the different royalties like 6%, 30%, or 40%, or a non-transferable right, like they remain with the original author. If you don't want to give a right to the other person, you have a moral right to keep your work your own. The economic scope of the economic right of the copyrights, like you can produce reproductions right. If like in the H.C. Verma has generated different editions of his book, so it's a reproductions right has given to the other person. Distribution right, your book is distributed, who can distribute your work is also come under the Copyright Act. Right to create or a derivative work, like a right to communicate to the public, and a right to public performance. Public right to perform the work in the public. Who can perform your work? You have to give your concern who can present your work in the public. So term of protections, there are the different protections, different term of protections for the different work, like a cinematographic film and the sound recording. It's a 60-year, while for the dramatic, artistic, and musical work, life of the author is 60 plus year. It's given a 60 plus year of right. Cinematographic, it is 60 year, but broadcasting and reproductions right is given for only 25 years, and performance right is given for the 50 years. So how we can do the application procedure? We have to file the form 14 for every such application can be filed in the Copyright Office by the person or by post or e-filing facilities. Payment can be done through a payment or a demand draft. So these are the fee for the applying for the different rights, like literacy, dramatic and artistic and musical, we have to need only pay 500 rupees. While for artistic work, we need to pay 2000 rupees. For the sound recording, we need to pay 2000, and cinematograph film, we need to pay 5000 rupees. Examinations process for the copyright is a applicant receive at a Copyright Office. Application received at the Copyright Office. If you file the copyright applications, it's received by the IP office or a Copyright Office. They will check a formality. Formality checks are there, and there are some waiting period. Then they check the scrutiny this applications. If there is any discrepancy, they issued a letter, and if they don't get any response regarding this issuing letter, the application can be abandoned. It means they stop this process. While if there is no discrepancy, approval by the registrar. If it is not approved by the registrar, hearing before the registrar. If there is any issue, he can schedule a hearing process. So in a hearing process, he can approve or reject these applications. So these are the procedure for copyright. Next is another IPR is a semiconductor integrated circuit layout design. So what is first we have to understand, because it's a new, most of the people are aware of trademark, like a copyrights or a patent, but this is recently added rights. The semiconductor integrated circuit means a product having a like a transistor and other circuitry element, which is are inseparably form on or inside a semiconductor or an insulating material designed to perform an electronic circuitry functions. So layout design means a layout transistor and other circuitry elements, which include the wire, connecting wires, element expressed in a manner to semiconductor integrated circuit. Semiconductor integrated circuit layout design registry, Delhi. Its office is present in the Delhi, and where the applicant on the layout design of integrated circuit are filed for the registration and created IPRs. So SICLD is an important IPR for protection of the product with a fast changing technology such as electronic gadget. As we know, all the new technologies are based on the semiconductor integrated circuit layout design. So it's very important protection. So it provides a very important protections for IPR. The registration of the layout design is for a period of 10 years for the date of application filing or the first commercial exploitations, whichever is the earlier. Next one, there is a procedure and uses of the semiconductor devices. So I'm not going through it because we will take a different session on this. Geographical indications is an important, another important IPR, which is not given to an individual, it's given to a community or given to a particular area or a state government. So geographical indication is an indication that identify a product that have a specific geographical origin and possesses qualities or reputations that are due to that origin. Like we can take example of Darjeeling tea. This Darjeeling tea is very Darjeeling tea. We know that the tea is very good, but Darjeeling tea is one of the most. It's considered as one of the more considered as the best of all this. Similarly, we can say that Nilgiri tea, and we can take some other example like Kanchivaram. Kanchivaram silk is very good in all silks, and Makrana marble. So these are the example of the geographical indications. Like some other famous geographical indications are the Kathputlis of Rajasthan, Bak print of Madhya Pradesh, Bengal, like a Worli painting. Yes, all these are the example of geographical indications. IP is everywhere. So there are some validity periods for the different IPs. Like patent is given for the 20 years. There is nothing called global or international because all IP rights are territorial rights. Territorial, it means it is limited to a particularly origin. It means Indian patent is limited to only India. If you want to write in other countries like a UK or a USA, you have to file a different patent application. Patent is a territorial right, and it's not a global right. Further design period is for 10 years. It can be extended to 15 years after filing an application. Is also initially given for the 10 years. Further, it can renew by filing applications. GI identify indefinitely subject to a renewal. Initially is given for the 10 years. Copyrights, the period of different copyrights is for the different copyrights for the different like it's generally for the 60 years.
Participants, please mute yourself. Please mute yourself.
All the IP can be filed by a individual person except the GI or a trade secret. Trade secret is also not filed by the individual
मैम
person.
आप म्यूट कर दीजिए, अर्पणा जी आप म्यूट कर दीजिए. प्लीज कंटिन्यू. हाँ डॉक्टर
So
नीतू जी मैं
before generating your IP or filing for your IPR applications, you need to remember some points. The first is to be first protect and then publish. It means if you are doing your research work and you generate a new technology, so first you have to file the patent application, then publish in a journal. So you should be remember that first protect and then publish, because the IP right is given from the first filing of your applications. Right are territorial. It means not a global. Yeah, I already told you that these rights are territorial. It means if you are filing the IPR in India, it's applicable only in India. So to find the rights in the other country, you have to file this application in the different applications for the other country. Registration is done by the government of India. Like for registration is right is given by the government of India. All the right is given by the government of India. Right is limited for a particular period of time. It means if you are getting a trademark for a product, it is limited for the 10 years. For it can be extended it can be extended by applying for the renewal of this trademark. No automatic relief. It means you have to understand that if you want or create a IPR, it does not mean that somebody will not use your IP, or it will not use your IP until and unless you cannot stop to use your IP until and unless you file an infringement suit. We can take an example of like Apple has filed an infringement suit to the Samsung. So after this infringement suit, Samsung has paid to a lot of money to the Apple for infringing his IPR. The renewal fee is to be paid some IPR. It means for some IPR you need to pay a renewal fee, like a trademark. For a design you have to need for renewal your application you need to pay again. Appointment of the patent agent is not compulsory. Like if you are filing a patent application, individual can also file its patent application by itself. It does not he does not require any patent agent to file the applications. Except copyrights and trade secret, you need a patent agent or a patent trademark agent, like for the different agent for this to filing the copyrights and trade secret. But for other rights, you don't need to require any agent. Further, this is what are the career opportunities in the IPR. So there are some government as well as private jobs are there in the field of IPR. So you can apply for the examiner of the patent and designs, examiner of trademark and GI, examiner of copyrights. The different qualifications are required for this. For the copyrights, we need to be specifically the person from the law can apply for the examiner copyrights. But for the patent and design, we don't need a person who is a law graduate. The person who is from science graduate can also be the examiner of patent and design. You need only a MSc in a science or a BTech, MTech can apply for the examiner of patent and design. Other than the government job, there are some other jobs in the private field, like a patent agent. Who prosecute these applications to the patent office are known as the patent agent, like a trademark agent, and GRF and SRF in the patent facilitation centers, patent litigations, and the other opportunities in the private sector. These are the career opportunities in the IPR sector. Now it's all about your different types of IPRs. So I have generated a quiz. How much you have gone through this this sessions? So you can give your answer in a chat or by unmuting yourself. So the first quiz is find the IP in first. What do you think? In a first figure, what type of IP is there? Anybody? Hello, am I audible?
Yes, ma'am.
Yes. Can anybody tell me in a figure first, what type of IP do you think is there? Nobody? Hello?
One picture.
Is not visible? Like this first figure.
Visible, it is visible.
Yeah, it's first figure. What do you think? What type of IP is there?
Copyright.
Yes, it's a subject of copyright. It's artistic work. And in figure second, what do you think? Anybody? Please.
What is this figure? This is
It's a statue actually, sir.
okay.
Also copyright.
It's a work of art.
Mm. It can also be a design patent. One product can contain more than one IP. Like in this figure third, how many copyrights are there? Sorry, how many IPs are there? In figure
Trademark.
third. Trademark, yes, Apple is a trademark. And
Then this
copyright.
we are not
Design.
able to see the copyright here because we
design
don't have any manual
technology,
here.
that
Design.
semiconductor
Design.
technology is there.
Design, yes. Trademark, like if in this, the Apple is a trademark, while the design of the Apple set is different than the other. So we can say that there are two IPs, like a design and trademark. In a fifth figure, in a fourth figure, there is how many IPRs are there in the figure 4?
Design, copyright,
Trademark.
Trademark. Whistler is a
Logo.
trademark. Yes. There is not logo. Bisleri logo is not there, but trademark is given not only for the logo, but other like word also. It's given for the word also. Slogan. In a figure 5, what do you think?
Fifth figure, trademark, copyright, and design.
Yes. Coca-Cola is a Coca-Cola written in this is a trademark, and design of this bottle is another IP, and third one is copyright. Copyright. How can you say that it's a copyrighted? In which we can get the copyright?
Dear drink formula.
Drink formula is a trade secret actually. Okay, next quiz.
Name is
So all of you are getting this session actually. Which type of IP protect the painting painted by an artist?
Designs.
copyright,
IP protect the painting painted by the artist.
design.
and
Trademark.
copyright.
Trademark.
Not a trademark. Painting
Design.
and
Design.
artistic
Design.
work come under the Copyright Act. Actually.
Copyright.
Okay.
For the design, you need a different type of design. If there are the different color pattern in that painting which are not applicable earlier, then we will get a design registrations. Okay. What protect the intellectual property created by a fashion designer?
And now it comes.
Hence,
Designs, yeah. There are three types of intellectual property rights. In
Copyright.
the
copyright
case
and
of
trademark.
copyrights and trademark
Design.
also. If we create a different type of fabric, it's also come under the patent also, if a different fabric. So
There may be some geographical indications also, no? In some cases.
geographical indications come for the particular
If
area.
a particular
if
type
we are-
of
Mm.
this pashmina, we can say.
So it's the fashion designer using pashmina, then he can say that the geographical indications is there. But if it is not using the pashmina, then we cannot say it's intellectual property. So mainly the fashion designer can protect the three: copyright, design, and trademark. What protect the advanced disc brake for a bike developed by an inventor? Advanced disc brake.
Trademark.
Patent.
We are not telling what type of who is branding this
Patent must be there.
bike. A patent must be there because he giving an advanced disc brake. There is some technologies available, so we can say that a patent. Mainly a patent. Next one. Which of these is a geographical indications?
Nagpur orange.
Yes, Nagpur orange is a geographical indications. It's especially giving a area Nagpur, then it means it geographically indicating the area. So it's a Nagpur orange is a geographical indications. What does a trademark protect?
Logos, names, and brands.
Logo, names, and brands.
Yes. Now, how long can a patent last?
60.
10 years.
It's for 20 years. Patent is long last for 20 years. Trade secret, trademark.
Trademark for 10 years.
Trademark and design it's last for the 10 years. It can be extendable. Design can be extendable to 15 years after filing applications for renewal, or we can extend the term of 10 years by filing a renewal application. So patent lasts for the 20 years. It's a 20-year considered for your date of first filing actually.
Okay.
If you write an original story, what type of intellectual property give you the right to decide who can make and sell copies of your work? Which intellectual property?
Copyright.
Yeah, copyright. Easy. Next is, if a company develop a new technology that improve its main product, what type of intellectual property can they use to stop other from copying their inventions?
Patent.
New technology if you are developing. The technology means there is some
Patent.
patent. Technology means patent. Name, artistic work, dramatic work, cinematographic work, all come into the copyrights, while logos, name, word come under the trademark. Geographical indications always contain a name of any place and area. So it's all about your today's sessions. It's more than 1 hour. I think it's more than 1 hour. It's 8:17 p.m. So thank you so much, sir. And thank you all the participants to listening me carefully. So thank you so much, sir.
Thank you,
for the
ma'am.
team. Thank you.
Thank you, Dr. Neetu. It was a very interesting session and made more interesting by the quiz at the end. So I'm also thankful to the participants, and our principal, Dr. UP Singh ji, is also there. Few words of encouragement from him will be the icing in the cake. Sir, are you available?
Yeah. Am I audible to you?
Yes,
Yes.
sir.
Am I audible to you?
Yes,
sir.
Yes, sir.
I think respected resource person, डॉक्टर पांडे जी, आज आपने बौद्धिक संपदा अधिकार पर, IPR पर एक अभिनव रोशनी डाली है। शिक्षण संस्थानों में शोध एवं नवाचार, इन दोनों क्षेत्रों में IPR की जानकारी बहुत आवश्यक है। और आपका जो ज्ञान है, एक प्रबुद्ध ज्ञान एक अच्छे शिक्षक का, क्योंकि मैं पूरे सेशन इसलिए जुड़ा रहा कि IPR एक बहुत महत्वपूर्ण टॉपिक है जिसको गवर्नमेंट ऑफ इंडिया ने बहुत लेट एक्नॉलेज किया 2016 में। और बौद्धिक संपदा को जो इंटेंजिबल है, बहुत परिश्रम करके, बहुत मनन करके, जो अन्वेषण या जो भी एक ऐसे कार्य हैं जो बौद्धिक है, मानसिक है, शारीरिक है, तमाम सारी शक्तियां लगती हैं किसी नए काम को करने में, जिसे इनोवेशन, नवाचार की बात की जाती है, शोध की बात की जाती है, चाहे वो शोध पत्र हो। तो आपने हर एक पहलू पर बहुत वृहद अच्छी वक्र दृष्टि थी। अंतिम का सेशन मुझे बहुत अच्छा लगा, जो इंटरेक्टिव था। तो निश्चित रूप से मैं कहता हूं कि आज के रिसोर्स पर्सन एक बहुत अच्छे शिक्षक हैं, जिन्होंने 1 घंटे के सेशन में अपनी ऑडियंस को बांधे रखा। तो मैं बहुत सारी मुबारकबाद देता हूं IQAC कन्वीनर डॉक्टर नीरज तिवारी जी को कि उन्होंने आपको इनवाइट किया। आज अपने लाजपत राय कॉलेज के प्रत्येक कोने में भले लोग केवल 72 जुड़े हों, 80 जुड़े हों, लेकिन यह जो टॉपिक था बहुत बहुत उपयोगी था। जितने भी हमारे शिक्षक बंधु जुड़े हैं, जितने हमारे विद्यार्थी जुड़े हैं, आज शायद वो IPR के सही मायने को समझ गए होंगे, रजिस्ट्रेशन की प्रक्रिया को समझ गए होंगे, और अगर वो तकनीकी ज्ञान रखते हैं तो उसमें रोजगार के कितने अवसर हैं उसको समझ गए होंगे। और निश्चित रूप से किसी शिक्षण संस्था में नवाचार, शोध, आविष्कार, ये चीजें ऐसी हैं कि मनुष्य जब भी सोचेगा तभी कोई नई सोच होगी, इसकी अभिनव सोच होगी, इनक्रेडिबल, तभी वो बनेगा। और पूरा हिंदुस्तान इस दिशा में अग्रणी है कि कोई चीज नई आए जो समाज के लिए उपयोगी हो, संस्थाओं के लिए उपयोगी हो। और IPR का जो मुख्य मकसद मैं देखता हूं कि हर एक इंडिविजुअल को उसकी इंटेलेक्चुअल प्रॉपर्टी को, उसकी बौद्धिक संपदा को, उसका एक उन्होंने स्वामित्व स्वीकार किया है। अभी आप बात कर रही थी 20 वर्षों तक, क्योंकि काल परिस्थिति सभी बदलते हैं, उनका स्वरूप बदलता है। उसी तरीके से शोध पत्रों में साइटेशंस, उनके कंटेंट्स कितने हो, प्लेजरिज्म से उसका क्या मतलब है। यानी कि हम सब एक ऐसे युग की ओर जा रहे हैं जो शायद मशीनीकरण है, लेकिन गुणवत्ता वहां होनी चाहिए। शायद हम सभी के शोध कार्यों में, शोध में, अध्यापन में, मनन में, या नवीन जो कोई भी सृजन करना है, तो जो क्रिएशन है, क्रिएशन की, चाहे वो आर्टिस्टिक वर्क हो, चाहे वो कोई मैकेनिकल डिजाइन हो, चाहे वो 2 डायमेंशन 3D या 4D कोई भी डिजाइन हो, या किसी भी चीज का एक अद्भुत काम करने का तरीका हो, तो बहुत अच्छा प्रेजेंटेशन था। आई अप्रिशिएट सो मच। आई थिंक मैंने भी बहुत कुछ सीखा आपसे,
Thank you so
मेरे
much, sir.
प्राध्यापक साथियों ने भी सीखा होगा। और मैं विश करता हूं कि कभी आपके लिए एक अच्छी तैयारी की जाए। जो गाजियाबाद की शिक्षण संस्थाएं हैं, यही नहीं बल्कि उनके जितने हेड ऑफ इंस्टीट्यूशंस हैं, क्योंकि हम छोटे छोटे प्रयास करके कहीं ना कहीं पेटेंट में एक दखल बना सकते हैं। हमारे समानांतर आप भी मेरे ख्याल से राजकीय संस्था में कार्यरत हैं, जो
Yes, sir.
बहुत सारे प्राइवेट यूनिवर्सिटीज हैं, प्राइवेट संस्थान हैं, वो हमारे यहाँ के, ऐसा नहीं कि हमारे साथी योग्य नहीं, हमारे साथी योग्य हैं, लेकिन शायद इन जटिल प्रक्रियाओं का जो एक स्वरूप है कि कितने स्टेज में रजिस्ट्रेशन करना है, अपनी चीजों को कैसे संरक्षित करना है, मेरे ख्याल से बहुत सारे जो अच्छे शोध के कार्य थे, चाहे वो पीएचडी की थीसिस थी, किसी का आर्टिकल था, या कुछ उन्होंने कोई मॉडल तैयार किया, वर्किंग मॉडल था या सिमुलेशन था, वो कहीं ना कहीं उनसे दूर चले गए, उनका स्वामित्व नहीं रहा। तो आपको बहुत सारा साधुवाद लाजपत राय कॉलेज की ओर से कि हम सब ने भी आईपीआर की जो बारीकियां आपने बताई, एक बहुत अच्छे शिक्षक हैं आप। आपका जो इंटरेक्टिव सेशन था वह बहुत मन को स्पर्श करने वाला था, क्योंकि आप एक ऐसे शिक्षक हैं जो पढ़ाते भी हैं और समझाते भी हैं। शायद इसी बात की उम्मीद है। तो पुनः मैं आईक्यूएससी को और हमारी जो आईटी टीम है, अपर्णा जैन, डॉक्टर चेतना मिश्रा, डॉक्टर जितेंद्र, जितने भी साथी हैं हमारे,
डॉक्टर अमन साहू।
डॉक्टर अमन साहू, मॉर्निंग ओनली ही वाज टेलिंग मी, क्योंकि ऐसी बात है कि एक मुझे तो लगा कि आईपीआर का एक गुलाब खिला, उसने बहुत सारी सुगंध दी, और शायद आईपीआर के बारे में हम सब दोबारा एक बार और असेंबल हों, क्योंकि ये जो टॉपिक है हम सब ने सुन रखा है, उसके बारे में थोड़ी जानकारी भी है, लेकिन जब हम थोड़ी गूढ़ता उसके प्रोसेस को समझ लेंगे तो कोशिश करेंगे कि जो हमारे अच्छे कार्य हैं उनको भी हम सब पंजीकरण कराएं, क्योंकि नैक की एक्टिविटी में या नैक की उपलब्धियों में एक आईपीआर भी है। जो प्राइवेट इंस्टीट्यूशंस हैं वह तमाम सारी जगहों से अच्छे लोगों को हायर करते हैं, उनके बायोडाटा लगाते हैं। तो आज मैं यह भी महसूस करता हूं कि डॉक्टर तिवारी का एक अभिनव कार्य था कि आपको आज एक वर्चुअल मंच पर लाए, और कभी भौतिक रूप से हम सभी भी आपसे मिलना चाहेंगे कि आप आइए और इस विधा के 2-3 लोगों को हम लोग बुलाएं दिल्ली से भी। और एक शिक्षक जो है वह हर रोल में बहुत अद्वितीय होता है। तो आई एक्सप्रेस माई ग्रेटिट्यूड to you and express my team that they have done a wonderful task and you have given a marvelous session of +1 hour. एक अच्छा शिक्षक वह है जो लगातार 1 घंटे पढ़ाने की क्षमता रखता है। Thank you, Dr. Pandey. And a letter of appreciation should be issued by IQAC. And मैडम के लिए कोई उपहार जरूर IQAC दे, ताकि उनकी भी यादों में IPR के भाषण की एक सुंदरता झलके। Thank you very much. जय हिंद।
Thank you so much, sir. Thank you
सर,
so much.
थैंक यू सर एंड थैंक यू नीतू। और मैं बताना चाह रहा था कि हम लोग थोड़ा बाकी जो सेशन है उनके लिए भी हमें डॉक्टर नीतू हेल्प कर रही हैं, और रिसोर्स पर्सन्स के लिए, और भी फर्दर प्लान है। हम सोच रहे हैं कि इनके कॉलेज और हम मिलके भी कुछ एक्टिविटी आगे कर पाएँ, क्योंकि इनका रिमोट में कॉलेज सिचुएटेड है, हमारा शहर में है। तो इस तरह का भी कुछ बात भी है, और प्रिंसिपल सर और हम लोग मिलके फिर इस पे आगे बढ़ने की कोशिश करेंगे।
श्योर, मोस्ट वेलकम IQAC, वंडरफुल जॉब। डॉक्टर पांडे जी, आपको बहुत बहुत शुभकामनाएं। थैंक यू वेरी मच। सभी साथी जो जुड़े रहे हैं मंच,
Yes, sure,
उनका
sir.
सभी साधु आता है।
Thank you so much, sir.
Thank you all. So we close the session now. Thanks a lot for attending the session.
हेलो नीरज सर, क्लोज मीटिंग एंड कर दूं ना? हेलो।